Imagine holding your newborn in your arms and not knowing whether your child belongs anywhere at all. Not knowing if the country where they took their first breath will recognize them or reject them. Not knowing if a simple line in a legal document could decide their entire future. That was not a hypothetical fear. That was reality for millions of immigrant families across the United States, until now. Because in a decision that will echo through generations, the Supreme Court of the United States has drawn a clear, unshakable line. A line that no executive order can cross. A line that protects one of the most fundamental promises ever written into American law. Birthright citizenship stays. 6 justices, a decisive majority, a constitutional principle reaffirmed. And with that ruling, one of the most intense and emotional legal battles in modern immigration history has come to an end. At least for now.
This is not just another court decision. This is a moment that reshapes certainty, identity, and belonging for millions of families. And to truly understand how big this is, we need to walk through what happened, why it matters, and what it means for the future of immigration in America. Let's start with the foundation. Birthright citizenship is not a policy. It is not a government program. It is not something that can be turned on or off depending on who is in power. It is written into the Constitution of the United States. The 14th Amendment, ratified in 1868, states clearly, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. For more than 150 years, that sentence has carried enormous weight. It has meant that if a child is born on American soil, that child is American, period. It has not mattered whether the parents were citizens, permanent residents, temporary workers, students, or undocumented immigrants. The place of birth, American soil, was enough. This principle is known as jus soli, or right of the soil, and it has been one of the defining features of the American legal and social system. It reflects a simple but powerful idea that citizenship is not inherited through bloodline alone, but grounded in place, presence, and equal protection under the law. But earlier this year, that long-standing interpretation faced one of its most serious challenges ever. An executive order was issued attempting to change how birthright citizenship is applied. The argument behind it focused on a specific phrase in the 14th Amendment, subject to the jurisdiction thereof. The administration claimed that this phrase was never meant to apply to everyone physically present in the United States. Instead, they argued, it should exclude certain groups, specifically undocumented immigrants and individuals in the country on temporary visas. Under that interpretation, being born in the United States would no longer automatically guarantee citizenship if the parents did not have a certain legal status. This was not a small adjustment. It was a dramatic reinterpretation of constitutional language, one that could have fundamentally altered the meaning of citizenship in America, and the reaction was immediate. Legal experts, civil rights organizations, state governments, and immigration advocates all moved quickly to challenge the order in court. Lawsuits were filed across the country. Federal judges began reviewing the legality of the executive action, and again, lower courts blocked it. Judges ruled that the executive order conflicted with the plain meaning of the 14th Amendment and with long-established Supreme Court precedent. They emphasized that the Constitution cannot be rewritten by executive action. But the legal battle didn't stop there. The case moved upward through the judicial system, gaining national attention, drawing intense debate, and raising a single critical question: can a president redefine who is a citizen without changing the Constitution itself? Eventually, that question reached the highest court in the country, and that's where history was made. In a 6-3 decision, the Supreme Court ruled in favor of maintaining birthright citizenship as it has been understood for generations. 6 justices agreed that the Constitution is clear. 6 justices affirmed that being born on American soil grants citizenship, regardless of the immigration status of one's parents. 6 justices rejected the idea that an executive order could narrow a constitutional guarantee. This was not a narrow or technical ruling. It was a firm and direct statement about the limits of executive power and the enduring strength of constitutional rights. What made the decision even more significant was the composition of the majority. The 6 justices who supported birthright citizenship were not all from the same ideological background. They were appointed by different presidents from different political parties with different judicial philosophies, and yet they came to the same conclusion. That matters, because it signals that this was not simply a political outcome, it was a constitutional one. The majority opinion leaned heavily on history, precedent, and the original purpose of the 14th Amendment. It pointed out that the amendment was designed to establish a clear, universal rule of citizenship, especially in the aftermath of the Civil War, when the country needed to define who belonged. The court also referenced one of the most important cases in this area, United States v. Wong Kim Ark, decided in 1898. In that case, the Supreme Court ruled that a child born in the United States to Chinese parents was a citizen, even though his parents were not eligible for citizenship themselves under the laws of that time. That decision has stood for more than a century, and in this new ruling, the court made it clear that precedent still holds. The dissenting justices, however, saw things differently. They argued that the phrase "subject to the jurisdiction thereof" deserves a more limited interpretation. They suggested that Congress should have more authority to define the boundaries of birthright citizenship, but the majority was not persuaded. They emphasized that the historical understanding of the amendment, combined with consistent legal interpretation over decades, leaves little room for reinterpretation. In other words, the meaning of the 14th Amendment is not up for reinvention through executive action. So what does this mean in real life? For families, for children, for people navigating the immigration system every day, what actually changes? First, and most importantly, the rule remains what it has always been. If a child is born in the United States, that child is a U.S. citizen. It does not matter if the parents are undocumented. It does not matter if they are on temporary visas like H-1B, F-1, or tourist visas. It does not matter if their immigration status is uncertain or unresolved. Birth on American soil is enough. Second, the executive order that attempted to change this is no longer enforceable. It has no legal standing. Government agencies, hospitals, and administrative bodies must continue to recognize and process citizenship as they always have. There is no gray area left on this issue. Third, this ruling provides a level of stability and certainty that had been missing for months. Families who were unsure, anxious, or afraid can now rely on a clear constitutional guarantee. That kind of certainty matters more than it might seem, because immigration law is often complex, shifting, and difficult to navigate. But this ruling creates one firm point of clarity in an otherwise evolving system. It also carries long-term implications. There are millions of undocumented immigrants living in the United States. Many of them have children who were born in the country. Those children are citizens. They always have been. And now that fact has been reaffirmed at the highest legal level possible. This can influence family dynamics, legal strategies, and future immigration pathways. While having a citizen child does not automatically grant legal status to parents, it can play a role in certain legal processes over time. Beyond the legal details, there is also a broader message in this decision. It reinforces the idea that constitutional rights cannot be changed by executive order. If a right is written into the Constitution, altering it requires a much more demanding process. Either a constitutional amendment, which involves approval from Congress and the states, or a fundamental shift in Supreme Court interpretation. And in this case, the court has made its position very clear. Looking ahead, this decision also shapes the boundaries of future policy efforts. It limits how far executive actions can go in redefining core legal principles. It signals that while immigration policy can be adjusted in many ways, through enforcement, visa regulations, or legislative changes, there are certain lines that cannot be crossed. Of course, the political reaction has been intense. Supporters of the ruling see it as a victory for constitutional integrity, civil rights, and legal consistency. Critics argue that it maintains a system they believe should be re-examined, and that debate is unlikely to disappear anytime soon. Immigration has long been one of the most complex and contested issues in American politics. This decision resolves one major question, but many others remain. There are ongoing legal battles involving asylum policies, deportation procedures, visa regulations, and programs like DACA. Each of these areas continues to evolve. Each has the potential to affect millions of lives. So while this ruling brings clarity to birthright citizenship, it does not mark the end of immigration debates in America. Far from it. But for now, it does settle something fundamental. It answers a question that goes to the heart of identity and belonging. Who is considered American at birth? The answer, as reaffirmed by the Supreme Court, remains grounded in place, not status. And behind all the legal language, all the court filings, all the arguments and counterarguments, there is a deeply human story. There are parents who spent months in uncertainty, unsure of what their child's future would look like. There are children whose entire sense of identity could have been called into question. There are families who built their lives in a country while wondering if that country would fully recognize their children. For them, this ruling is not abstract. It is personal. It is immediate. It is the difference between fear and relief, between uncertainty and stability, between questioning belonging and having it confirmed. And that is what makes this moment so significant. It is not just about law. It is about people. It is about the meaning of citizenship in a modern world. It is about the role of the Constitution in protecting individuals, especially those who may not have a voice in the political process. And it is about the enduring idea that some principles are meant to stand firm, even in times of change and conflict. The Supreme Court has spoken. The Constitution remains the foundation. And birthright citizenship, one of the most defining elements of American identity, is still intact. For millions of families, that means something simple but powerful. Their children belong, fully, legally, unquestionably. And for now, that certainty is not up for debate.